2020, and then in January of 2021, it began.
It began?
Yes.
Good. Very good. Now, Samson, this case that was filed in 2021, at the time it was filed, I'm very clear in my mind that the Republic had their own evidence, done their own investigations, built the theory of their case, put their facts together, and then filed before the court. There was no issue about what? Recorded a tape at that time.
That's correct.
Good. The prosecution mounted a box, called their witnesses, closed their case. A1.
Okay, so it is this way. Filed December 2021, and in January 2022, the process began. Yes.
Right. But then it is clear that the issues complained of started between 2014 and 2016. These are the facts, isn't it?
That's right.
Good. Now, Samson, at the time when the prosecution entered the dock, mounted the dock, led evidence in the case and everything, closed their case, the issue of so-called doctored tape had not arisen. For even backtrack, at the time when settlement conference was going on, document was being exchanged by the parties. The so-called tape had not arisen. The case closed. Submission of no case was filed by A1 and A3.
Jakpa and
Forson. And this is very, very, very instrumental. The court said, no, it's a case for you to answer. Now, let me go to that point. You see, it is very, very, very instructive. Very, very instructive.
I've read the entire ruling on the submission of no case.
No, yes. It's very instructive in terms of the findings made by the court that a case has been made for them to open their defense.
Right.
So let me refer you to page.
They are only supposed to punch a small doubt
Exactly.
in the Republic's case, and the Republic will lose.
Exactly. Now let me go here. The judge said, and I'm referring to page 4 of the ruling that we are dealing with. He said, submission of no case dated 30th March 2023. This court concluded that a prima facie case has already been made to merit all the three accusations then to open their defense. Now listen, something. That the matter was settled. That the ambulances in the state in which they were delivered could not serve any useful purpose. But the assertion was made by the cross-examination and the evidence put forward, particularly A3, that there were moves to fix the defects, thereby proving the case that there was no loss occasion to the state. It means that at this stage, there is a case which has been made that the loss is occasion. But as to whether the loss is willful, and who caused the willful act, that is yet to be determined.
And I'm happy you read this portion.
Good.
You know why? Because I'd heard commentaries, including respectfully from Sami Jamfi, right after this decision throwing out the applications. That suggested that the judge had done something in predetermining the matter.
No.
By suggesting that the state had established that the vehicles that were delivered were without useful purpose. But if you read the decision, she actually highlights this. She says the matter was settled that the ambulances, then she begins to highlight, in the state that they were delivered, that's highlight, in the state that they were delivered, could not serve any useful purpose. She did not say, emphatic, that the matter has been settled, that the ambulances could not serve any useful purpose in the state that they were delivered.
Good.
Yes, go on.
Now you see something. At this stage, then A1 now mounts the box. Leaves evidence in chief, is cross-examined, call witnesses, 3 of them, and closes his case.
Ato Forson.
Now, Ato Forson is here. He said, further, there was the issue of what authority the first accused person exercised what he asked for the LC to be issued. It is a case of the prosecution that the LCs were issued without due cause and authorization. The prosecution is stating that A1 had no authority, had no authority. He stated, among others, that the agreement that culminated in the delivery of the defective ambulances, which cannot be used in the condition that it is. Now, A1 also called the Minister for Finance, who came to testify for him, and close his case. All these stages, there's nothing called recorded tape. You see something, and this is very instructive. Prosecutors go to court, do their investigation, build a theory of their case, take the evidence with them, put it before the judge. Just accept that there's a case for you to answer. You also come and want your defense. A1 closes and is off the dock. A3 now comes because A2 has been discharged. Then at this stage, you start your evidence in chief. You put your witness statement in there. And then you are now being cross-examined by counsel for A1. A1 and A3 are on the same path. And even the direction by the judge that A1, lawyer for A1 cross-examine A3, is a settled matter of appeal, which they find a stay.
Because they believe the Attorney General should do their work before they come in.
But they are on the same path. A1 and A3 are on the same path. Their interests are coterminous. All right?
So actually, for those of you who have not followed, one of the applications seeking to hold the hand of the judge not to do anything is in respect of this particular one that is pending in the court, because they are saying that you have done something that we disagree with you. You said, you said Ato Forson's lawyers should cross-examine Richard Jakpa before the Attorney General. We don't agree with that. That's not what the practice is. So that's why one of the applications was asking for a setting stay, and the judge refused it. Yes, go on.
And even in the appeal they filed, they didn't particularize any particular error of law made by the judge.
We'll not go there. Let's stay here.